tonight we're going to continue to build on the rights of nature discussion, which is central to community rights work. We started with Winona LaDuke in the fall, in November, followed by Vandana Shiva in like 2 days later. And then after that, CELDEF's Mari Margill in January, Movement Rights Shannon Biggs in February, and tonight we have U of O Professor Craig Kauffman. Yay! We're trying to normalize the whole notion of rights of nature. I think when we first started talking about this, people were really shocked and a little quizzical, skeptical, but it's starting to become really just a normal part of parlor conversation, rights of nature. So, and from a community rights perspective, nature's rights needs to be legally authorized and recognized and protected by law. The perception of nature only as property denies nature's inalienable right to exist, persist, and flourish. And the system that neglects the rights of nature will not fix itself. It's really up to us here. So you folks, we folks, are the ones that are tasked with a fairly large job, but no better work than this, right? I also like to remind folks that along with rights of nature, community rights applies to a broad range of rights, including environmental rights, the right to clean air, water, and soil, worker rights, the right to a living wage and equal pay for equal work, and democratic rights, such as the right to local community self-government, which includes our right to write and pass laws that protect our health, safety, and welfare. Here in Lane County, we're working on, and many of you know this, we're working to do something very similar to what happened in Lincoln County, which is the freedom from aerial herbicide spray ban. And so if you haven't signed, back right by Anne in the back of the room, you will find petitions. Please sign that one. Also, in concert with that one is the right to local community self-government, which gives us the right to write and pass laws. It gives us the right to pass and enforce the spray ban. They don't work independently of one another. We need both of them. So make sure that you sign both of them. And to that end, we want to talk about rights of nature with Craig Kauffman.
So thank you so much for those very kind words of introduction. And I guess I want to say I'm inspired by meeting the members of the Rights of Nature Working Group here in Lane County, just as I've been inspired by many other communities around the world that I've seen experiment with these big ideas, but put them into practice in their communities. And in so doing, they've tended to inspire others and attract attention, and they've been scaled up. And it's really creating real change, both locally for them, but also internationally. And so part of what I wanted to do today was to give you a broader picture of how what's happening here in Lane County fits into this broader global movement. Partly, I guess, just so you don't feel like you're alone. But also because what we're seeing is this experimentation with this idea of rights of nature is leading, as experimentation does, right, with different kinds of applications. So rights of nature laws are starting to look different in different places for different reasons. And so I want to go through some of the similarities and differences, and then we can maybe think about the implications of that. And then I wanted to spend some time looking at the key obstacles about putting this stuff into practice, right? It's one thing to get enough social momentum to get a law passed, right? But just because you get a law passed that says nature has the right to exist, to maintain its integrity, to function, so forth and so on, doesn't mean the mining companies don't still want to build open pit copper mines, right? Or so forth and so on, right? And so there are going to be conflicts. You will be sued, right? And so part of what I want to do is share the experience that happened in Ecuador, because Ecuador was the first one to grant rights to nature in its constitution. Not the very, so you may know the very first rights of nature law was actually in the US, in Pennsylvania, but it was a township ordinance that doesn't have the same standing as the constitution of a country, right? Once you pass rights of nature in the constitution, it automatically grants legal standing. But you're going to have these conflicts, and so it's the one place where the legal standing has been there long enough that we've actually now had a decade of lawsuits, and you can see how jurisprudence gets developed and the obstacles to the growth of jurisprudence and the strategies that activists use to try to overcome those obstacles and so forth. So that's what I want to talk about today. Just as, I guess, a little bit of an introduction to put what the kind introducers said in a little bit of broader context. My interest in rights of nature stems from my work in Ecuador since 2003. I've been working with communities, both indigenous and non-indigenous communities in Ecuador since 2003, around their quest to try to envision a new method of what sustainable development would look like that's not based on a Western notion that development means exponential growth in perpetuity, right? And that also doesn't view humans as separate or apart from nature, right? So so they start from a very different perspective where humans are part of nature, not separate or apart, and that the goal of development isn't increasing exponential growth in consumption, but rather trying to find some equilibrium in the biotic community and then maintain that, if you can, right? And so I watched and studied and helped in any way I could various experiments in a number of communities in Ecuador where they led to some new, really innovative local watershed management experiments, for example, where they implemented this vision in their local watersheds. And this inspired more movements to scale it up nationally, and through a story that I could tell you during the Q&A period if you're interested, and it's also told in my book, that ended up leading to the establishment of the rights of nature clauses in Ecuador's constitution. The Constitution was written in 2007 and then passed in 2008, right? And I watched that process happen, and I was fascinated because, as you all know, the idea that nature has rights is not a new concept. It's an old idea. It's at least several decades old in Western thinking, and it's arguably hundreds, if not thousands of years old in many non-Western traditions. But what really changed is one of the first times it got codified in Western law, and that was surprising. And since then, it has diffused quite rapidly. And to give you a sense of that, I wanted to just sort of show you the list of existing rights of nature laws as they exist right now. So Ecuador's constitution was the first one at the national level in 2008. Shortly thereafter, a couple of years later, Bolivia passed the law of Mother Earth, Ley de Madre Tierra. And then in 2010, it was a national law. In 2012, there was sort of an adjustment to the law to make it what they call a framework law, which basically gives it precedence over all other laws. So in other words, Bolivia's, it's not in the Constitution, but it's somewhat like being in the Constitution because it has the special status of being what they call a framework law that makes it superior to other laws. Meanwhile, during kind of the same time period, you've got through CELDEF and people like the work of Shannon Biggs and Linda Sheehan and many others, there had been just an increasing number of municipalities, communities throughout the U.S. I've been able to count 43 at this point. I'm not sure. Meanwhile, then in New Zealand, you have two national acts, in other words, national laws. And the reason why there are two of them is because they grant rights to specific ecosystems. So it's somewhat different from Ecuador's constitution. And I'll get into these similarities and differences in a little bit. But then just this year, you've had Mexico City recognize rights of nature in its city constitution. That's no small feat, because Mexico City is the 5th largest city in the world. When last I looked it up, it's like 17.5 million people. So I mean, that's even more than Ecuador's entire population. So that's a significant step. India, just several months ago, I think it was in April if I'm not mistaken, you had a high court ruling that recognized rights of nature through even though they don't have a law, you have now a high court ruling that says the politicians have to do these number of things that respect the rights of the Ganga and Yamuna rivers, and then some glaciers, as well as forest ecosystems and so forth. I can talk about that as well. Almost immediately after, Colombia, the Constitutional Court in Colombia makes a similar ruling. And there are laws before the legislatures in Argentina, Brazil, Nepal, Australia, and a number of other places. And so, in other words, there is actually some there. So you're seeing this spread quite rapidly in domestic laws. But there's also interesting stuff going on at the international level. In 2009, right after Ecuador's constitution came out, the fact that a lot of people were inspired by that, right? And because it was proof of concept. Again, the idea wasn't new; it was an old idea, but it was proof that you could actually put this into practice, and it made it sort of real, right? People saw what it could look like. And so it prompted members of various environmental groups from around the world, indigenous organizations from around the world, human rights organizations, so forth and so on, different kinds of movements gathered in Ecuador in 2009 to try to see how can we build on this momentum. And they formed an organization called the Global Alliance for the Rights of Nature. Shannon Biggs, Vandana Shiva were among the founders of that movement. And then the following year, in 2010, they were so disappointed by the failure to make progress at the Copenhagen Climate Summit in 2009 that they said, we got to do something about this. And so they met in 2010. They held a World People's, I think it was called the World People's Congress on Climate Change, as sort of parallel movement. Literally thousands and thousands of citizens from around the world came to this to talk about these topics. And they established a citizens' declaration. So it has no formal authority, but it set this normative tone. That said, no, we believe there should be a universal declaration for the rights of Mother Earth. And it was basically modeled on the rights of nature principles in Ecuador's constitution. And immediately it got support from the Ecuadorian government, not surprising, and Bolivia's government stepped on. And Bolivia's government, the president, Evo Morales in particular, sort of took this on and became a force in the UN system, in the international system, and started arguing that there needs to be a UN declaration on the rights of nature, just as there is a UN declaration for human rights, that we have to set this as a norm that sets the values for what we expect for countries to have in their national laws, so to speak, right? Of course, it didn't happen right away, right? So there were these proposals in the UN, and a lot of countries said, I don't know about that. But they kept at it, right? But so what happened is Ecuador's government and Bolivia's government got a number of other governments together to essentially vote in the General Assembly to establish these annual dialogues to discuss the issue further, to keep the discussion going. And they call these annual dialogues on harmony with nature. So they started in 2010, again coming out of this Universal Declaration. And it's happened every year, and it's building momentum. And as a result of that, they then had the UN Secretary General create annual reports. And during those years, it was Secretary General Ban Ki-moon, who became a sympathetic sort of fan and took on the cause. And if you read the Secretary General's reports, he starts to increasingly argue for the needs for rights of nature to be established in international law. So it starts to become not this marginal radical idea that's only espoused by these pariah states like, Ecuador or Bolivia or something like that, to now you're seeing the discourse being advocated by some serious world leaders, like the UN Secretary. They get it. In 2012, you have the renegotiation of the Sustainable Development Goals. And I won't go into the background of this, but suffice it to say, for those of you who sort of studied international treaties around this, you may have heard of the Kyoto Protocol, right, around climate change and efforts, Agenda 21 around the Rio Summit, Earth Summit, to try to promote sustainable development. That was established in 1992, and in 2012 they had this sort of meeting and said, okay, it's been 20 years. How well did we do with achieving sustainable development? Not so good, right? Maybe we should rethink the sustainable development thing and maybe establish some new goals for how to deal with sustainable development. And so that happened in 2012, and the Global Alliance for the Rights of Nature mobilized to try to influence that, to try to shape this notion of let's reimagine what sustainable development means and see if we can try to move away from this idea of it being all about linear exponential growth and consumption, right? And they had some success. They actually got it into the final document, and Article 39 actually recognizes the rights of nature as an important principle, essentially, right? This is the way international treaties work. But it's kind of important because when you get these principles established in international law, they sort of set the framework for discussion and expectations. And then Pope Francis decides to pick it up as a cause, right? And he speaks at the 2012, his first speech, to my knowledge, on that really advocates for rights of nature, happened at the opening ceremony of this Rio +20 conference. And then later he incorporates it into the encyclical Laudato Si, right? And so now again, it's becoming more mainstream. It's becoming more normal in international discourse, to the point where the IUCN, this isn't on the screen, but the IUCN, the International Union for the Conservation of Nature, which is the first and largest international environmental organization, several years ago passed a resolution saying that the rights of nature should be at the basis of all of its policy decisions. That's no small effect, because this is an international NGO who has projects around the world and who's sort of sets the tone for environmental NGOs working elsewhere. And in 2015, after the Paris Climate Agreement, the UN General Assembly passed a resolution saying we need to establish what they called Earth-centered law, right? That it's not enough to just rely on the kinds of environmental laws that we've had in the past. And so they passed a resolution calling for the formation of this knowledge network to make recommendations for how you would put Earth-centered law or rights of nature into practice. So it's now become actually part of the, and so I became I'm a member of that knowledge network, and last Earth Day, so last April, we presented the report. So in 2016, following the resolution, we met and came up with our recommendations, and then those got presented to the UN General Assembly at the annual dialogue, right, that's held on Earth Day every day. And then it was surprising to me to see the receptiveness among states. So I can tell you it is growing. It is becoming more normal. I mean, it's not going to happen overnight, right? But you are starting to see some real change. So, and a lot of it's being being promoted by this Global Alliance for the Rights of Nature and other sort of transnational networks. So what I wanted to do today, as I said, is give you kind of my sort of quick analysis of a couple of questions. One is, what explains this timing, right? Like, why now? Again, and why does all this seem to be happening like in a clustered way? So, it's happening all together. And why do the rights of nature laws, though, look so different? And the reason why that's puzzling to someone like an academic like me, I won't bore you with the theory or anything like that, but it's that, when we tend to see a whole bunch of policies come out all at the same time, they usually look alike because there's this diffusion mechanism going on. People are borrowing, you have one model that looks really good and other people want to adopt it, right? So we would expect, because of the clustering, for these things to all look very similar, or but they look really different. So part of what I'm trying to do as a researcher is to try to explain that puzzle. And in short, essentially the explanation is, I borrow an idea from evolutionary biology of convergent evolution, if you guys are familiar with that concept, right? And basically the idea is this, so if you think back to Darwin's insight from the Galapagos Islands, right, he noticed that there are all these species that have functionally similar features, but they're all different, right? They all kind of do functionally similar things, but they evolved to meet that functionality differently, right? And so in the same way, what I believe is happening is that the timing of these rights of nature laws is explained by the fact that communities around the world, like yourselves, are responding to common global pressures that are, characteristic of the age of the Anthropocene, right? And to give you an example of this, the UN High Commissioner for Human Rights recently has been tracking human rights abuses, but also increasingly abuses of what they call defenders of nature, defenders of the environment. Because what they've documented is that the increased global competition for natural resources has become so fierce and intense that it's produced a level of environmental degradation that we just simply haven't seen before, and it's producing greater environmental degradation felt at the community levels, and it's producing increasing conflict between communities and corporations and states who are vying for those natural resources. And you can chart the correlation between that increasing competition for extraction of natural resources and increasing conflict. And one of the data points for that is the rise of murders of human rights activists and what they call co-violations. Violations of both human rights and rights of nature. That's the sort of the co-violations. And the reason why they're talking about co-violations is because people who think about human rights have sort of come to the conclusion that the human rights laws that have been on the books for a long time and that people have been working to promote for so long appear not to be sufficient, essentially, to protect humans, right? To protect communities, right? And so communities are searching, like you all, right, are searching for alternative tools to fight back. And they're experimenting with different ways to do it, to put it bluntly, right? And that's why, and because they're experimenting in different sociocultural and political and economic environments, their experiments cause their legal endeavors to evolve in different ways, but to meet functionally similar pressures, right? So in other words, we've got you have these rights of nature laws that are functionally similar in the sense that they are designed to value nature and communities and support these norms that humans are part of nature, not separate or apart from nature and so forth, and that, that this notion of community should be understood as the biotic community and so forth and so on, and therefore, and that you need to prevent environmental harms, not simply mitigate them, right? So there are these functionally similar features of all the laws, but they are expressed very different, and I'll give you some examples of that in a second. But then, so once I kind of give you a sense of that, then I want to give you some insight into some other questions that I ask in my research, which is, can these rights of nature laws actually stop environmental degradation, right? Like some of you may recall, right, in the 70s, there was a lot of high hope that, the strong environmental laws that were created in the 70s would do the trick, and they haven't, right? And so it's one thing to pass the laws, it's another thing to have them actually stop the environmental degradation. And so then what are the key obstacles and strategies? And I'll give you some insights or lessons based on Ecuador's experience. So if you can go to the next. Right, so here's just some basic examples of how the rights of nature laws differ. And I picked Ecuador and New Zealand and the USA. Of course, there are a bunch in the USA, and they don't all look alike, but I've sort of given you some common characteristics of many of the local ordinances in the USA. These are sort of three typologies, if you will, models that seem to be kind of diffusing around. And they were sort of the first, and now that they've been established, other later countries seem to be taking pieces of these models, right? So, for example, Bolivia's laws look almost identical to Ecuador. The new India ruling is clearly explicitly modeled on New Zealand's, as is Colombia's, and Mexico City's looks more like the USA's, and so forth and so on. So, and I can talk about that more if you like in the Q&A period. And so, one of the ways that they differ is that they simply define nature differently, and that's important, right? If you're going to talk about rights of nature, it matters how you define nature and who gets to represent nature, if there are any sort of disputes, and what are the array of rights that you should grant nature, right? And so there are some differences. Ecuador is the most expansive in the way it defines nature. You know, and the reason why they're different, just as a background, is because they evolved out of these contestations among different social groups in a particular distinct political setting, right? So in Ecuador, it comes out of the struggle of environmental activists and indigenous groups to establish what they call a post-neoliberal development model, right? This alternative development model, and they had this window of opportunity to try to pursue it through when they had the opportunity to write the Constitution, and I can explain that story in the Q&A period if you like. But suffice it to say, you know, this window of opportunity opened, and so they got to write this Constitution. And the writing of the Constitution was very open and participatory. And essentially, different civil society groups were invited to make recommendations, and they were presented with the question, what is the Ecuador you want to live in? What does it look like, right? They were asked, essentially the whole country was asked to do this visioning exercise, and then to send in their proposals, and they were organized according to different working groups and so forth and so on. And so if you read Ecuador's constitution, in the preamble it says, we dedicate ourselves to a new approach to development rooted on this Ecuadorian indigenous concept of sumak kausai, which suffice it to say is different than the Western notion of development, right? But as a result, it's heavily infused with Andean indigenous, for example, Quechua concepts. And the Constitution then goes to say we will then implement this new vision of development by granting three sets of rights: human rights, community rights, and rights of nature, essentially, right? And they're seen as integrated. And so that's how rights of nature, in other words, rights of nature was framed as a tool for achieving this new vision of sustainable development that they wanted to achieve. And so to the extent that nature is, the only time nature is defined in the entire law, the Constitution, is at the beginning when it defines nature as Pachamama, which is this Andean deity that's difficult to translate into English, but it sort of would roughly be analogous to Mother Earth. But it's an expansive notion of nature, right? It's not a particular river. It's not it's not an individual animal or a particular river, so forth. It's the earth. It's all of the nested ecosystems, right? And so the rights to nature are granted to all of those. So in other words, it transcends political boundaries. That's the key piece of this, right? So for example, when the BP oil spill happened in the Gulf here in the US shortly thereafter, there were lawsuits to sue BP in Ecuador, invoking the Ecuadorian Constitution under the argument that this has universal jurisdiction because nature is defined as Pachamama, universally, right? So it matters how you define nature, right? Who represents nature? In the Constitution, it's very clear that anyone can represent nature. in a lawsuit, right? So if anyone, doesn't matter if you're an Ecuadorian citizen or not, doesn't matter if you were harmed by some particular environmental disaster or not, if you see what you think is a violation of nature's rights, you can invoke a lawsuit to try to protect them. And what are the rights in other words, what are the rights that were granted? I guess I should clarify if it's not clear already. So the rights are granted to ecosystems, right? They're not granted to, say, individual animals. So this isn't like animal rights. It's the rights are granted to these ecosystems. So ecosystems have the right to exist, to maintain their integrity, and to be restored if damaged, right? So very different. So Ecuador, most expansive. New Zealand, in many ways, is the least expansive. It has two national laws. Each law only recognizes or only grants rights to a specific ecosystem. So there's one law that recognizes the Wanganui River as having legal personhood status and therefore rights, and another one, this Tairua Forest, right? So it's not all of nature doesn't have rights. Only these two ecosystems have rights. And that has to do with the fact that the laws came out of these treaty negotiations with particular Maori iwi or tribes that were negotiating with the Crown, New Zealand's Crown government for, outstanding treaty settlements. And that part of their demand was that, that in the case of the river, that the river be recognized the way that the Maori view the river, as a whole living spiritual being, right? Not a set of resources that can be divided up, sliced and diced and used in different ways and owned by different people or what have you, right? So they decided that the best way to achieve their ends after literally decades and decades of failed negotiations, they decided ultimately that what they really wanted was they wanted the rest of New Zealand to really understand the river ecosystem the way they understood it, because they figured once they do that, then a bunch of other stuff will flow from that. If you can just get people to understand or view the river as a living spiritual being, as a whole entity, right, then the other stuff will flow, was the idea, right? And so the rights granted are very limited. In fact, it doesn't really talk a lot about rights. What it does is it grants legal personhood status to the river or the forest. And what that basically means is the rights they have are rights of access to the political process or the legal process, right? So in other words, nowhere does it say that it has specific rights to exist or integrity or be restored. It's just there's recognized that it has interests. Right, and so it gives it access to have standing in court. Basically, is really what it comes down to. So then you say, okay, well, who's gonna represent the forest? Who will speak for the trees, right? Who will speak for the river? And so then there are two appointed guardians that. So it's not anyone can't represent nature, but just the guardians of the river can speak for the river, and the guardians for the forest can speak for the forest, right? And I can talk more about why that is, or what have you. But so then there's the USA cases, which you guys are probably in many ways more familiar with than I am. All right, but most of the ones that I've looked at, again, the nature is defined as ecosystems, with local ecosystems within, and typically they tend to be ecosystems that are under threat, and there's a desire to try to prevent some threat, right? So the early ones were to try to prevent further threat from sewage sludge. Increasingly, you're seeing them in response to try to prevent gas fracking, aerial spraying, what have you, right? But they're kind of specific. But you're defining it as natural communities, right? Because there's this notion of community rights. And so who represents nature? And a lot of them, typically, they're then city or municipal citizens can, but that's one of the things you kind of have to think through when you're designing these laws. And one of the interesting things about the USA is a lot of the American or the United States ordinances is that they tend to grant one extra right the right to flourish, which doesn't often appear in many other rights of nature laws around the world. And that may sound trivial, but it's actually really important when you think about what that will imply for when it comes to creating regulations and the secondary laws for actually enforcing the law, right? So when you create a law and then you want it to get put into practice, that means you have to then figure out how you would monitor. How would you know when a right was violated, right? Humans are going to always have an impact on nature. We're part of nature. That's part of what it means to be part of nature. There isn't this idea that we will never impact nature. So there's got to be some threshold, though, beyond which our impact is too much, right? And in the Ecuadorian case, indigenous peoples that I work with, they explained the threshold that they came up with to me like this. Look, when you break your arm, it happens. You know, it's unfortunate, it hurts, but you bandage it, you heal it, it can be restored, it'll heal itself, and life goes on, right? But if someone cuts off your arm, it's not going to grow back, right? So there's a fundamental, if you look in the law and then the secondary regulations that are like the penal code and the things like that start to specify what it would look like in specific instances to violate the rights of nature and therefore what the punishment would be. There's this kind of line driven between, you can damage nature, but so long as it can be restored, you have an obligation to restore it, but it's beyond that, it's not a violation. The violations clearly are when the damage is so severe that species go extinct, an ecosystem is so severely damaged that it can't function anymore, right? It's essentially erased. It's like you've cut off the arm. That's a pretty low bar, right? That's an unsatisfyingly low bar for a lot of people, right? And so in many communities, there's been added more recently this notion that, well, we wouldn't like it just to sort of minimally exist and sort of limp along with broken limbs, right, all the time. We would like it to flourish. We would like it to be healthy, right? Well, so how do you measure health? What is a healthy ecosystem, and how would you know that? Those questions haven't been answered yet, and there are environmental lawyers and political scientists like myself that are trying to figure out those questions and think about what it would look like. How would you measure the health of an ecosystem in a way that you could know whether or not some specific economic activity violated the right to flourish, right? So these are the reasons why it matters how you define nature and decide the array of rights that you grant. So we can go on. So I just want to make sure we have plenty of time for Q&A. So I just want to give you a quick overview of kind of Ecuador's experience. So these are the array of rights, just as a reminder that Ecuador's constitution grants nature. It has a right to exist, to maintain its integrity as an ecosystem. So again, nature is understood as a set of nested ecosystems. And by maintaining its integrity, in other words, it has to be able to regenerate its life cycles, its structure, its functions, its evolutionary processes. So for example, those of you interested in GMOs, right? So Ecuador and Bolivia explicitly list in their secondary laws, like their penal codes and so forth, introducing alien biological elements and GMOs as a violation of its ability to maintain its structure, because you're altering sort of the structure of the ecosystem. So to give you an example of what that looks like. And then, so again, the focus is on the ability of the ecosystem to regenerate itself, right? So if it's injured, then it has the right to be restored, independent of human claims for compensation, right? So there may be humans who are hurt economically, right, by restoring something, and maybe they need redress, but that's a separate issue from the right of the ecosystem to be restored. Anyone can bring suit on behalf of nature, and they have encoded the principle of preventive action. And that's another difference that you see between these rights of nature laws. So one of the reasons why the Ecuadorian laws are so strong is because it explicitly says that if you have information that, even if the violation has not yet occurred, but you have information that reliably suggests if some activity went forward, it would likely result in a violation, then you can take preventive action. The Constitution essentially says the state has an obligation to take preventive action to stop that activity until you can figure out a way to do it in a way where it won't produce the violation, right? You don't see that in some other, so like New Zealand's doesn't have that, and many of the US rights of nature laws don't have this explicit preventive action measure. So if you can do it. Right, and so as you can imagine, right after the Constitution is released, so the new Constitution had a number of principles in it, and it was a compromise and negotiation, like all constitutions are. And not everyone who eventually was a member of the Constituent Assembly loved all of the features of the Constitution. Nevertheless, the power dynamics were such where that was the compromises that were made. But shortly after the Constitution was passed, then you have elections for the new legislature under the new Constitution and so forth. And the political dynamics of who got elected in the national legislature afterwards were very different than the power dynamics in the Constitution. In other words, advocates of rights of nature, to put it bluntly, had seats at the table in the Constituent Assembly, but their opponents dominated the national legislative elections afterwards. So they had the law, but they didn't have any real power in the new National Assembly. And what that meant is none of the required secondary laws got passed, essentially, right? The government, the legislature at least, said, we're basically just going to ignore this, right? And that happens often, right? It's almost cliche to talk about unimplemented laws in Latin America, right? So, and the U.S., right, in many places. And immediately afterwards, the government announced its new development project based around an expansion of mining and announced a new open pit copper mine and so forth, right? And so now you have this clash, and the social movements that had succeeded in getting the rights of nature principles into the Constitution had to decide what they were going to do. And the tools at their disposal were essentially a series of lawsuits based on these constitutional principles, since they had decided it was not, basically it wasn't going to happen through the legislative process for a variety of reasons that I could talk about more later if you like. Right, so they then, in terms of lawsuits through the courts, they had a number of avenues. You could have a constitutional lawsuit that challenged the constitutionality of laws, and the very first effort to invoke rights of nature in the Constitution was to challenge the state's mining law as simply unconstitutional. That got struck down quickly in due order. So then they said, okay, they backed up. When I say they, I'm talking about this alliance of indigenous and environmental NGOs and environmental lawyers who had been involved in crafting the rights of nature principles and who were working to sort of advance this, right? And they said, okay, we've got this Constitution, it's powerful, we need to use it, right, to try to put it into practice, right? And so they decided as their strategy that they would pick the most high-profile. Well, let me get to that in a second. So there's the other kind of lawsuits they had were criminal lawsuits and then administrative actions. So I spent a number of years trying to document all the ways that the rights of nature laws in the Constitution were actually implemented. And I wanted to know, why did some lawsuits succeed while others failed, right? And so I've written and published stuff on that. I want to sort of tell you the story of the pathways and the obstacles and the strategies that ended up strengthening rights of nature jurisprudence and law, because that has actually happened in Ecuador. So the first thing was that you had civil society pressure, right? And this is that's the way you would imagine it would happen, right? That you would have these social movements that work so hard, they were organized, they're building social momentum. And so they're going to now bring lawsuits to try to force the courts to recognize these constitutional principles. So their first effort was to challenge the constitutionality of the mining law. That failed. They then said, okay, we're going to combine social protest with a really high-profile lawsuit because we want to raise awareness of this, try to shame the government. We're going to pick the most slam-dunk case where there is a clear violation of the rights of nature and it gets a lot of attention. So they picked the country's first open-pit copper mine project because because it was high-profile, highly politicized, and it was a clear violation. You were talking about an 8-kilometer in diameter hole, a kilometer and a half deep and 8 kilometers in diameter hole in the ground that even the mining company's own estimates, environmental impact statements, acknowledged that there would be the extinction of numerous species endemic to that region. And all that material, it's not just the whole, so literally whole ecosystems were just going to be eliminated, right, dug out of the ground and removed, right? That's like that's clearly cutting off the arm. That is not breaking the arm, that is cutting off the arm, right? And then not to mention all that stuff you dig out of the ground has to go somewhere. It gets dumped in the rivers and that has tremendous environmental impacts. And so they, pretty clear violations of these constitutional principles. They, long story short, went to the Supreme Court and they lost. And the ruling was, the justification for the ruling was a little bit absurd in the sense that it clearly was not consistent with the Constitution. Basically what the lawyers said was, they found against the lawsuit on 2 grounds. The first was that the negative environmental impacts would not happen within a national park or like an ecological preserve, which ended up not being true anyway. But even if you assumed that that was true, it shouldn't matter, right? Because the rights aren't granted only to nature in national parks. The Constitution said it's granted to all of nature. It should have no bearing as to whether it's a national park or not. And then the other logic of the ruling was that they decided that the civil society's interest in protecting the rights of nature was a private interest, whereas the state's interest in promoting development through this extractivist project was a public interest, and the public interest took priority over the private interest. So you can see that which is clearly absurd, right? And so a lot of the activists interpreted this as the fact that the politicization is undermining this effort and the judiciary is not independent and we're never going to win because there isn't an independent judiciary. And there's some evidence to support that. I was able to get a hold of a memo from the then president, Rafael Correa, that was sent. You can't really read that, but I'll tell you what it's about. It was sent by his minister, essentially the minister of the judiciary, that was circulated among all the lawyers and judges, among the judges primarily, that threatened, so it decried the, quote, illegitimate abuse of the protective action provided for in the Constitution to challenge public works. In other words, he was really upset that this constitutional provision was being used to stymie or obstruct these state development projects. And then he said, any judge who approves a preventive action against a state is going to has to personally reimburse the state for damages and harm incurred as a result of suspending the project. And the amount of the harm would be calculated by the minister on a case-by-case basis, right? And so this was obviously interpreted by judges as don't rule against the state. So there's that going on, but there was another problem that was also just simply a lack of knowledge among judges about what this rights of nature stuff is, right? I mean, most of these judges are not environmentalists. They had never really heard of this. It seemed like an odd concept. Their training teaches them that property rights are king, right? And so, even if it wasn't politicized, and some judges and lawyers push back and be like, look, we do have an independent judiciary. It's not as, yes, it's politically charged and all that, but we are professionals and it's an independent judiciary. And that the real problem is just simply that there's just this lack of knowledge among judges about how you would interpret these provisions. And there's some evidence for that. And so the rights of nature activists learned from this, and they could have took a step back, and they said, okay, we're going to work then instead with kind of below the radar, meaning we're going to try to find like non-politicized local cases that don't really challenge the state's development project, and therefore may not get caught up in this politicized context and immediately get shut down. And we're going to then also create a system to train judges just so that they're aware of this and they sort of understand the legal interpretation. And we're going to try to just build some jurisprudence quietly on the ground through these local cases. And they did that, and that's where they had success. All right? So the first successful rights of nature lawsuits in the world were through these local cases that went sort of below the radar. They also, though, they didn't give up on the highly politicized cases. They just used a different strategy, right? So they then kept up their social protest, right? So they launched a national campaign to try to pressure the government not to open up the Yasuni Ecological Reserve to oil extraction. So for those of you who don't follow Ecuadorian politics, which I'm assuming is most of you, basically the point is one of the most biologically diverse areas of the planet, literally, I'm not exaggerating, is in kind of the Amazonian part of Ecuador. And one of the last pieces of that had not already been sort of delegated to oil extraction was this Yasuni Ecological Reserve, and it had been protected. And long story short, the government for a long time had vowed never to open that up to oil extraction, but then said it was going to open it to oil extraction, and so the movement, rights of nature activists, created this national campaign to try to block access to Yasuni, and they carried out this movement to get enough signatures to hold a national referendum on whether or not you could drill there. And public opinion was clearly against drilling there, and in part because it clearly violated the Constitution. Not only would it violate sort of rights of nature provisions, but it would also clearly violate certain indigenous rights provisions that I won't go into now. And so they got enough signatures to hold a referendum. They delivered, if you can go back one. They got enough signatures to hold the referendum. They delivered the signatures to the National Electoral Commission, who somehow mysteriously lost them. But fortunately, Yasunidos, this movement, had backup signatures. They had made copies because you never know what's going to happen in Ecuador. So then publicized what had happened and resubmitted the signatures. And the very, very embarrassed Electoral Commission just refused to make a decision on it. That ended up giving them they could make a lot of hay from that, because while not all of the Ecuadorians were that environmentally active, what it really highlighted was the fact that the Correa government was clearly violating the Constitution and acting in a non-democratic authoritarian manner. And most Ecuadorians did care about that, right? And so it tied into other concerns about the authoritarian nature of the government, and it led to mass social protests and put a lot of pressure on the government. And the result of that was that the government was forced to at least adopt the rhetoric of rights of nature, if not the action. And what that meant was that the government started invoking rights of nature and pursuing rights of nature lawsuits in cases that were we call, and political scientists call this instrumental, meaning it was useful for them at the time, right? They didn't necessarily believe in it per se, probably, but when it was useful, they would invoke rights of nature, and when it was not useful, they wouldn't recognize it. So you get a lot of hypocritical decisions. And a good example of that was that, the Ecuadorian government, before it made this new pronouncement on mining, there wasn't actually a lot of mining in Ecuador. It was mainly oil extraction. It hadn't bothered to really do the mining because it had so much oil. But the oil was running out, and so the government decided, well, okay, now we have to pursue the mining. But there had long been what they call artisanal mining, sort of small-scale, family-based mining. And it was illegal in the sense that it wasn't regulated. But it had long existed. And the government, part of the government's mining law was that it required all mining operations to be regulated and sort of nationalized because the state wanted to sort of control the concessions and all that sort of thing. And so it announced it was going to crack down on what it called illegal mining, meaning these small artisanal miners. And it invoked rights of nature, this desire, the need to take preventive action to protect these rivers. And it got a judge to make a ruling declaring a state of emergency and authorizing the state to take preventive action to send in the military to these communities to destroy the mining equipment. They seized, confiscated, and literally blew up with dynamite the mining equipment of the stuff. And then there was...
Actually to protect the large corporations?
So I have no evidence one way. I have no evidence of the motive, right? So one can surmise. So on the one hand, to be fair, a lot of the local community members had been complaining about the environmental degradation and health effects of that illegal mining, and they had been long asking the government to try to do something about that. So it's not as though there wasn't this backdrop and a local conflict surrounding that. It's just that it looks weird when on the one hand it's saying we're going to crack down on that, but we're going to allow this open pit copper mine whose environmental degradation is magnitudes of order more significant. It's the hypocrisy there that makes one wonder what the motivation is. And a cynic would say, yes, the state wanted to control the concessions of who got to mine because that would make the mining concessions more valuable. And so if I were a betting man, I might bet that way. Right, but those kinds of decisions by the state, while instrumental and hypocritical, actually had important legacy effects because it expanded the legal precedent. So to give you a sense of that, after that set the precedent that that the rights of nature take precedent over private property, that you can destroy private property to take preventive action to protect the rights of nature. That got put into the penal code subsequently because of that preventive action. These cases got a lot of attention, as you can imagine. So judges learned about it, and it did a lot to raise awareness among judges about these rights of nature provisions, what they are, sort of its seriousness. And so that then had unintended consequences, which is that you're now seeing judges unilaterally invoking rights of nature in their sentences, even when neither claimants nor defendants invoke rights of nature in their lawsuits. Right, because judges are saying, and they're not based on any normative arguments. In other words, the judges aren't sort of environmental activists. What they are professional jurists, right? And they say, look, the law is what the law is. Like, for better or worse, this is the Constitution we have, and we have an obligation as judges to interpret the law in its entirety. And there are these rights of nature that have to be balanced with other rights. And the Constitution says that the rights of nature are transversal, meaning that they affect all other rights. And by this time, you had increasing precedent from these below the radar cases that had, for example, established that rights of nature take precedence over municipal autonomy. And that, for example, the rights of nature take precedence over private property, so forth and so on. So they established the hierarchy of rights, which is another important way that these rights of nature differ. So in the US, the hierarchy of rights tends to be built in to the rights of nature, right? So for example, like you explicitly say corporate property rights are below rights of nature. That doesn't exist in most of these others. And so the hierarchy of rights had to be established through these lawsuits and through the emerging jurisprudence. And so there's some evidence, I think, that within the professional, what political scientists call epistemic communities, these knowledge communities of judges, basically the professional society of judges, there's some evidence that they may just be internalizing these rights of nature norms, right? Saying we have to interpret cases considering these in the larger context, right? And then there's also increasingly now the bureaucracies like the Ministry of Environment is invoking rights of nature to justify actions that it normally takes just as part of its mission, and it would take anyway, and it could do so without invoking rights of nature. So for example, protecting endangered species, it doesn't have to invoke rights of nature to protect endangered species, but it increasingly is doing so and is actually suing. So there's a number of these criminal lawsuits where they literally found poachers of a jaguar and a condor, which are protected species, and put them in jail, invoking rights of nature. And again, the fact that they could have done that through their existing mandate, yet they're invoking rights of nature, tells you something about how norms get consolidated through bureaucratic routine, right? And that's an important, for those of you who, and that's important because that's really what we're talking about, right? We're talking about you establish laws which are weak initially, right? Meaning they're still going to be challenged, but they are tools. They still matter. Weak laws matter is one of the big lessons of this, is because even though it's not going to be applied or implemented immediately right away, it changes the game because it provides activists tools to challenge vested interests. And that over time, there can be these sort of legacy effects, and jurisprudence can expand. And more importantly, once you can use that as a frame for changing habits, that's how the norms and values change over time. And that's really what ultimately so the goal isn't to have the laws, the goal is to get the value change, right? To get people to think about nature different. But the idea is that the law is a strategy for doing that sort of long term. And so I just want to end up by giving some sort of lessons, right? So one is that the reality is that I can't think of a case around the world where the rights of nature ultimately aren't going to be applied through lawsuits. They all are. That's the way it's working, right? So in New Zealand, so in Ecuador, it was because you couldn't get the political will to pass the regulations, right? You just have these. So you have the law, and then it's up to advocates to try to defend the law. In New Zealand, the laws just simply grant these rivers and forests legal standing, but that's it. Like if the guardians decide that the trees' interests are being defended, they have to go to courts, and the lawsuits are going to decide whether, right? It just grants them standing. That's all. In the U.S., the municipal ordinances, once they start to violate commercial interests, if the corporations decide that it's worth it, they fight, right? And we're starting to see lawsuits. None of them have been resolved yet, or at least none of them have been resolved in rights of nature's favor. But it doesn't mean it won't happen. But those cases are just sort of emerging. But in each case, it's happening through lawsuits, right? And the obstacles are the politicization surrounding this. They're the obvious obstacles that I'm sure you guys know about, right? That in legislatures, economically powerful groups have greater leverage in legislatures. They have less leverage in courts. So that's the good news, right? That the courts can be and are starting to be the protectors of rights of nature, right? It's not happening through, the legislators may pass the law, but that's not where it's being implemented. It's being implemented through the courts. But to do that, you've got to overcome the problem of just the lack of knowledge among judges, because it's a foreign concept to judges, right? And so you often can build judicial momentum better initially by working below the radar and training judges. At least that's the experience. And I know that sounds counterintuitive, right, to activists. That shouldn't be the way. But it is the way that rights for minority and marginalized groups have been strengthened in other cases. So it's the story of how LGBT rights got strengthened in the US. It happened through this working below the radar strategy. It didn't happen through, it's the story of gay parenting rights. So while it may sound weird, there is evidence that, when you have a case where it's so controversial, like an issue where it's so highly controversial that the politicization of that topic may undermine the ability to get it through the courts, that often it works better to try to build the judicial momentum quietly, for what it's worth. And for those of you who are interested in this, my colleague at University of Oregon, Alison Gesh, just wrote a great book studying this process of how it happened in LGBT, on the issues of LGBT rights and gay parenting and that kind of stuff. But it's not as though the big, highly politicized direct action doesn't matter. It does, because you can affect the instrumental action of the state, which can matter because that can raise awareness and maybe set precedent and so forth. And there's some evidence that in the Ecuador case that over time that can lead to norm internalization. That direct action that's high profile can help lead to norm internalization among judges and bureaucrats. And so weak laws do matter. So it matters if you can get a ballot initiative passed, even though it's going to be challenged and it's unlikely to be implemented overnight. And so last point I'll make is, and the other evidence of this is in the most recent rights of nature laws are increasingly coming through courts without even laws happening, right, through what's called public interest litigation. So in India and Colombia and Netherlands, you are having courts take advantage of a legal principle called public interest litigation that, to put it in a nutshell, essentially in some legal systems, I don't know if we have this in the US, I don't know if we do or not, I'm not a US legal scholar, but in some systems like in India and the Netherlands and Colombia, it is in the legal system where if a national law is not adequately protecting some protected marginalized group, that the courts have an obligation, that a group can create a lawsuit based on the public interest, right, to defend the public interest, and they can have standing to do that even if there isn't a law, and the courts can make rulings to force politicians to implement programs, rulings without laws in the public interest. And that is essentially what happened in Colombia and India. Colombia, the court ruling came in November 2016, but it just got sort of announced a couple of months ago. And in India, in April 2017, you had these long-time public interest lawsuits by communities, much not unlike yourself, that worked its way up and eventually got the courts ruled that, yes, in the public interest, nature needs to be protected, essentially. So that is, I'll stop it there. I know so I didn't leave as much time for Q&A. I'm willing to stay, though, as long as you guys like. I know you guys, so we can talk later. So let me take some questions.
Are you all working on an ideal model that could be put out around the world and see if
I don't think there is an ideal model. And so this is about, so the short answer is I don't think that would be my best use of time because I'm not convinced that there is an ideal model. I think that more important is what has to be identified are the underlying norms that are going to be consistent, that the laws will reflect. but that could be operationalized in slightly different ways because different countries have different legal systems. And so it would be hard just practically to design laws identically that would fit into every legal system around the world. That's the practical answer.
Without identifying the legal system, if you identify principle.
So we are identifying principles, and there are things out there like that. And then the other thing that we are working to identify is ways to measure violations so that you can start to create codes and regulations to implement this stuff, because that's what has to happen. You have to get it into the habits of bureaucracies that then are going to be the enforcement mechanism, right? And to do that, you have to know when if you see any given activity, how do you know if it is a violation of rights of nature or not, right? That's where at some point you have to move from principle to the practice. And so that's kind of where we are. That's sort of the cutting edge. That's the frontier now. It's trying to figure out how do you develop a coherent set of measurement tools for knowing when a violation has occurred or not in a way that would allow, the ministry, some Department of Transportation or the Department of Environment or whoever would be able to govern, essentially.
And it seems like you either wait for the corporation to violate this law and cut the arm off, so to speak, or you conduct civil disobedience just to get this thing into the courts and have it solved. Mm-hmm. Or you do this first option on your last slide.
Yeah. So yes. And groups, ideally all three things are happening simultaneously. I know that's really hard, but that's one of the challenges. And the reason is because there is this symbiotic relationship between efforts to get these norms, implanted into law, codified into a law, but then also the law being used to try to influence the norms, right? So it's one of these weird things where, it's a process of normative change, right? That's, and the first step is you got to get enough normative change where you get a sufficient number of people to buy into the idea that you should establish this law, right? But that's usually not sufficient to get necessarily broader society or the most important economic actors or whoever to buy into it, right? And you often then need more normative change to actually implement the law. And so there's this, I don't know what the best metaphor is, this tug of war, so to speak. There's interplay between you have to have social action to raise awareness and try to create that normative change in society to get the law passed, and then you have that tool, but that's not the end, right? Like you have to then use the tool to try to make more normative change to get it implemented. And there's going to be resistance. And so different communities are responding to different environments. And so in the US, it just happens, I don't really know why, but I can just tell you sort of anecdotally, the vast majority of communities in the US are doing this in response to an existing sort of threat, right? That's just sort of the way it's happening here in the US. Whereas in some of the other, like in the New Zealand and the Ecuador, it wasn't, there's lots of stuff going on that they were resisting, but it was sort of this broader project by indigenous groups to sort of fundamentally change the way people view ecosystems and understand what development is. And I don't know whether one's better or worse. I just think that's the way it had to happen in those environments.
Thank you.
If you take the assumption that the biggest threat to the global environment is CO2, then if that's the biggest threat, then will this movement for the rights of nature be the significant way that we limit carbon emissions? And so what I'm going to ask, because you know what's in the other silos, what silo is going to be the one that saves us from carbon?
So I'm going to answer your question directly because it's a good one, but it may not be the kind of answer that you anticipated or expected. So the short answer is yes, I do actually believe rights of nature movement is going to be. So when when I think about climate change and the need to get off carbon, so let me answer your question by tell you a quick story. So I was at the Paris climate talks, and one of the things that struck me most was that two ideas that 5 years earlier had been considered incredibly radical and only espoused by like fringe groups were now being taken seriously. And the one was geoengineering, this notion that we'll tech our way out of it. And the other one was rights of nature, right? And the third international tribunal, I didn't really talk about the tribunals for rights of nature, but the third international tribunal for the rights of nature took place at this Paris agreement. And there was a lot of, and the reason is this, that, after Paris, what was important about Paris is that there's no longer debate in the international community about the science, whether it's real, how bad the threat is. Everybody sort of accepts, outside of the sort of the U.S. domestic politics, everybody accepts the seriousness of the crisis, right? Which is why at Paris they agreed for the first time on specific goals, right? Everybody agreed that, okay, we know the crisis is bad, we know we need serious action, we recognize that we all have this goal of ideally limiting warming to 1.5 degrees over pre-industrial levels, at least 2% degrees, right? So then, and the quid pro quo was that then everybody comes up with this voluntary agreements for how they're going to try to move to that direction. And then in the countries, governments submitted their draft voluntary plans, and it was immediately clear that the plans were going to come nowhere close to meeting the goal, right? Like at best, even if they were going to be implemented, it would probably lead to at least 4 degrees, right? So then the discussion all turned to, well, how are you going to bridge that gap, right? And then you had these two sort of groups, if you will. One was what I call the geoengineering group. We'll tech our way out of it. We'll invent some technology that, and I won't bore you with geoengineering, what that is. But the other then, and that was based on a technological approach. And I hate to tell you, but it's the stronger of the two, politically stronger because it's politically convenient. Because the message is, you don't have to fundamentally change your systems or behaviors. We'll find some tech solution. But there's a strong and I think growing group of citizens and governments that are saying the tech we need tech, but that's not going to be enough. At best, tech can just buy us some time. Ultimately, we're going to have to change our behaviors. That's going to require value change. How do you do value change? Well, through legal change and forcing people to do it. And so rights of nature is gaining traction in the international system, as I showed on that one slide, because of climate change. I mean, that's really what's driving it internationally.
Isn't the other side public trust in that the government can't allow corporations to kill people?
Yeah, so I started my introduction by saying that I'm looking at, there are all kinds of earth-centered, all kinds of experiments with earth-centered law. Rights of nature laws are only one. There are other kinds of earth-centered laws, like invoking the public trust doctrine, and for those of you who know the Our Children's Trust lawsuit is an example of that. So again, they share the basic normative features of it, but the laws look different and draw on sort of different legal principles. So I consider that in the broader, that's why the UN calls it earth-centered law. They don't talk about specifically rights of nature because it includes these other kind of legal doctrines like public trust, where you get to the same outcome just through a different legal principle.
A number of years ago, people were talking about the precautionary principle a lot. And I'm wondering how that might dovetail with the rights of nature.
So it's essential. And that's why in a lot of laws, like Ecuador's and Bolivia's government, and in the Universal Declaration and so forth, it's built in. That's why they talk about preventive actions. So there's typically clauses that say, as I said before, the principle is if you see an action ramping up and you have like some company has planned to do some mining project, if there's reasonable scientific evidence that suggests that carrying out that action is likely to produce some violation, that you don't allow that action to go forward until you can figure out how to do it in a way that doesn't violate the, and that is a common clause in a lot of rights of nature laws.
Hypothetical, bringing it all back home. If you were a member of a local rights of nature group, how would you begin the journey of realizing some gains this way here in County?
Yeah, so I should have a better answer for that, but my problem is I'm a relatively recent transplant to Oregon, and I'm just not familiar enough with Oregon politics, and particularly Lane County politics, because one of the lessons, because I spend all my time in New Zealand and Ecuador and India and studying these other ones. And so that's why I've been very interested to meet you all and learn more. You know, other than these general lessons that I tried to sort of impart here, you know, I don't know how to answer that question. I have to think about that, unfortunately. I'm going to have to punt on that and get back to you because I have to think about more about the dynamics of the politics here to know, like, specific strategies.
Can you give an example? On one of your earlier slides, you said that it was a successful strategy to educate the judges. So making an alliance there, how could that work right here in Eugene and County? You know, do our local judges rule on these kinds of things? And if so, you know, meet and greet, whatever.
Well, so judges aren't going to. There has to be law, right, for the judges to then interpret.
How was it done when you said it was?
Well, so they had the law. So in Ecuador, it was in the Constitution. Judges are beholden to the Constitution. They have to interpret the Constitution. So you had that basis. And so it was a different problem from the one that you faced. Like that story is about what do you do after you get the law passed. In some ways, it's sort of like, I guess I'm jumping the gun a little bit with you all, because you're in the early phase of how do you get the law passed. And that story is about, okay, now you get the law passed, what do you do then once nobody wants to implement the law, right? And so there are so a better example are Grant and Highland townships in Pennsylvania. Have you had speakers talk about that? That's where your models are. So to give you an example there is some experimentation and adaptation, but it's been around structuring the law or the ordinance in a way where judges will recognize the legal standing. And that's one of the challenges here in the US because we have a federal system and these are bottom-up laws as opposed to top-down constitutions. And so, for example, Grant Township learned from Highland Township's experience lawsuit where they lost on standing, and so then redesigned the law to be a home rule charter, right, which then gives them certain legal standing. And so that's part of the trick here in the US is you have to find a way to design the law such that local judges will decide that you have standing, meaning that if the fracking company says, but Pennsylvania state law says I can do this, and that should have precedent over this township law, right? So that's the dilemma here.
Yes, in Ecuador, are they talking about the loss of the Andean glaciers?
About the loss of the Andean what?
The Andean glaciers, the water.
Yeah, absolutely, absolutely. So that was a key impetus for the movement, among other things. So water and forest rights, but particularly water rights. So Michelle, you've been wanting to answer.
I want to know how the flying under the radar is applicable to us. You know,
Yeah, because you're already at the local level. Like, what are you going to do that's not?
No, not just that. It's just that when you talk about LGBT rights or queer parenting, it really doesn't have economic implications.
Yeah.
What we're doing, we're talking about stopping forestry practices.
Right. Yeah, I'll have to think about it. That'll have to be a conversation we continue to have, and I'll have to talk with my colleague Allison. Maybe we could get together and talk about that. I think we're out of time. But I'm happy to go as long as you want, but I don't know if we're out of time. take 2 more questions? Okay.
Okay, I just want to say, I think that judges learn from each other.
Yeah.
And it looks to me by the findings that are coming from Kauffman and Aiken,
Mm-hmm.
that they are learning.
Yes.
And my guess is even though they are federal judges, that our local judges will be learning something from those findings that they're making. And
Yeah,
so
I suspect
I
so.
think there's some hopefulness there. I find a lot of hopefulness in
Yeah.
that language.
And the Indian and Colombian judges that just did these public interest lawsuits cited explicitly as precedent the New Zealand laws in their ruling. So they clearly are learning, and that's why they adopted the guardianship model.
But have they gotten to the point where they've actually been able to see judicial action against moneyed interests?
Yes. So yeah, I did it. So the answer is yes. I can give you a real quick anecdote, and I've got some published case studies that I can send you guys if you want to read the case studies. But the short of it is, in Ecuador, one of the most powerful economic interests is the shrimpers, because Ecuador's biggest export, that's not oil, is shrimp. And on the coast there are all these shrimp farms, and for a variety of reasons, a lot of them over the years have moved into these endangered mangrove ecosystems that were protected. And so then there was the lawsuit to protect the mangrove ecosystem to force the shrimp farmers to leave, and it went up to the Constitutional Court. And basically, in the end, the court ruled that the rights of the mangroves took precedence over the property rights of the shrimp farmers and ruled the behavior. So that's the first, and that's no small factor, because the shrimp farmers are it's a big industry there, and they're powerful in Ecuador. So it is the first time, that happened in 2016, that ruling, and that was the first time that you really got a ruling that challenged an economic interest. So again, this is an evolving story, right? Like it's not an issue of you pass the law and you flip the switch and everything changes. It's you pass the law and then you have a basis to start the fight, right? And you try to slowly build the jurisprudence.
But in 8 years, they went from essentially no response to challenging him very.
Yeah, they went in 8 years from the Supreme Court just dismissing it out of hand to ruling on behalf of the mangroves over the shrimpers.
Again, thanks.
Thank you.